Well, good evening. Alex Woods here, posting on the 17th of February. This is a case that I've actually referred to previously. This is a different type of issue that come up from the same case, which relates to the problems of procedure versus evidence in the small claims track. A lot of people assume that, it's all about getting your case out there, convincing the judge that you're in the right, absolutely sort of bombarding, drowning the court in paper. And this is exactly what happened in this case. Now, the facts of the case I'll rattle through. They, as I say, you can watch the previous vlog to get a little bit more of an insight into the facts of this case. But essentially, it's an architect, professional, one-man business who's got little time to be fighting a small claim, and he has brought a claim against a client who has basically not paid all of his invoice. So the small claim amount was £2,500. Now, what is interesting about this is that he brought this claim thinking it was going to be a very straightforward claim and that she would simply have to cough up. But he then discovered that she submitted a defence saying that the drawings that he'd done to convert her house were not only didn't like them, but had actually created sort of a defect or a problem, construction fault, such that it was going to cost her money in order to remedy the defect. So here you've got, hence the title, sort of a clever ploy in which, having initially just filed a defence, she then made an application to the court to have a hearing listed. This is at Wandsworth County Court in London, for permission for her to add a counterclaim. Now, of course, when you're a professional, you're running a business and you're faced with a client who you believe is swinging the lead, then you're being forced to take a commercial decision and perhaps drop the case altogether. And that's exactly what the opponent here was trying to get my client to do, in my view. And she had a lot of time on her hands. She was actually unemployed. She was obviously spending a lot of time and effort, putting a lot of love into doing a renovation of her house with some substantial structural changes. And she'd become dissatisfied. I don't know, the relationship had broken down. But it transpired that the actual work that he'd done did add value to the property. And in fact, when she replaced him with another architect, that architect and the structural engineer involved did seem to indicate, we didn't go to trial, but for my money, it seemed to indicate that he'd done a good job and their drawings were building on what he had done. So it did seem as if, once you really delved into the detail of the case, that she was completely swinging the lead and just using the court system and a counterclaim, which, he was claiming for £2,500, she was claiming for £5,000, knock his claim into touch. So basic litigation tactic. Now, anybody who's got involved in the courts as a lawyer or a litigant in person will know that, unfortunately, the fact of life is that there's a lot of complex rules around civil litigation, and you really sort of, it's a little bit like a game of chess in some respects. And unfortunately, you just simply need to learn a little bit of procedure. Now, you can, I think, get 75, 89, 90% of the way there, but sometimes you have a situation crop up. Anyway, to cut to the chase, what did he do? What did he do about this? Well, the court had listed the claim for trial, but 3 weeks before trial, it had also listed it for this hearing in which she wanted to add a counterclaim. It's a right hook attempting to knock the claimant off balance. And the fact of life is the courts are extremely busy. Judges don't have time to get intimately acquainted with the rights and wrongs of each person's case. Unfortunately, it's an entrepreneurial endeavour bringing a claim, and you have to be smart and you have to fight hard. And you can't just say, well, I'm right and he's wrong. You have to take actual action to demonstrate that. And why it's relevant here is you have to be smart about the procedure, about complying with the procedure. Now, for the geeks out there, all of this is there in the CPR, and you can buy the white book about that thick, or you just go online and look at all the relevant sections of the CPR that relate to your particular problem. Okay, so let's get down to the nuts and bolts of the kind of the issues that arose here. He didn't know how to deal with the counterclaim and how to prepare for this 45-minute hearing. He was slightly alarmed at what to do, and he produced quite a weighty-looking set of documents in response to her weighty set of documents that supported the counterclaim. So, well, the key here, if you can take anything away from this vlog and take this away, is it's not about evidence, it's not about these sorts of interlocutory hearings, they're called, because they aren't the trial itself, they're hearings that occur during the course of the proceedings. It's all about procedure. Resist the temptation to hammer the judge, the court, with the wrongs that have been done to you and the evidence in support of your case, and deal with what's in front of you. Here, it was an application to, as I say, to add a counterclaim to the defence. Now, here's an interesting thing. So when you look at the timing of it, the procedural side of it, she'd actually, earlier on, when she filed her defence, said that I can't file a counterclaim now because I'm unable, she should have done, at the time you file a defence, you should file the counterclaim, because I don't know what the amount of damages are. I don't know how to quantify my counterclaim. Now, it subsequently transpired that, in fact, there was correspondence which demonstrated to us that she'd got the invoices from these other professionals, the architects, the structural engineer, who'd apparently had to repair the damage done by my client, got these invoices. These invoices were dated prior to the time at which she filed her defence. So it was a bald-faced lie to say that she didn't have the financial information at the time. She did have financial information at that time, because she had at least some, I think actually all documentary evidence, which she later then on relied upon. The other thing is, she hadn't actually, even when it came to the hearing for filing her counterclaim, sufficiently clarified, the technical term is particularised. She hasn't said exactly how much the claim was, even though she had these invoices. She just dumped all this information on the court. The invoices were, swirling amongst all the other paperwork, but she hadn't submitted a clear court-friendly document saying, I am claiming 5,033 pence, against the claimant, and please find attached invoices. So we were able to say that she hadn't properly particularised her claim, and she'd had plenty of time to do so. We were also able to say that she had this information quite a long time ago. Okay, so why hadn't she done it when she first was filing her defence? We also did, but only as a sort of a minor part of what we said at court, of the particular hearing itself. We also said that we thought that her counterclaim didn't have any merit, and the client produced quite a good, on one page, although even that was too long, she should have done it on half a page, explanation of how it is that professionally it's often the case that architects complete a stage of a job and then hand on to other architects, in this case after planning consent has been obtained. So he actually, in a short paragraph, did address the deceit of the counterclaim. And just so, a seed of doubt was sowed in the judge about just what this particular defendant was, the game that she was playing. So this was, good success for me in terms of advising a client over the phone rather than actually having to go to court and properly prepping him up. The other thing that we did was, and here is, perhaps the fourth point to make in relation to this case. The courts, obviously will send you out paperwork, and not just litigants in person, but even bloody lawyers themselves never read this documentation. Here's this documentation. which will appear in front of your screen now. And it's quite a detailed court order. Allocates the claim, for example, to a particular track, a small claims track. It puts down deadlines for when evidence must be exchanged between the parties. She was actually in breach of one of these items, and there are a lot of numbered points on this court order, which was sent months before this hearing. So we were able to make another procedural point. Now, the hearing was a success, but you never know quite what judge you're going to get and how thoroughly he's read the papers. So the other thing I advised the client to do was actually to write a letter, because our client had been remiss in a particular area in terms of filing and submitting documents. Not a serious one, but that I got the client to draft a letter saying to them, apologising to the court for the late response to the counterclaim, because we were objecting to having it admitted. And we should have, responded earlier, because we were actually sending a letter to the court on the evening, or actually the morning. The usher gave it to the judge on the morning. So apologising for the late response to the defendant's counterclaim and listing the points that I've just listed to you on a letter. Giving that letter to the other side, you must always disclose the other side so they've had a chance to respond to you in court. Okay. And then going into court, and then the judge has, I've got a letter that's handed me by the usher this morning, and I've read it, it's not too long, don't drown him in documentation on the morning of the hearing. And the hearing went well. He was clearly on the side of our claimant, who was far more organised and unhappy about the lack of particularisation and the quantification of the claim. They ended up settling it. Actually, the judge said, go away, you two, and settle it. And she dropped her counterclaim, and they settled it for a reduced figure. He took a hit, but at least he got something for his invoice and didn't have to fight a counterclaim all the way to trial. And importantly, reputationally, had actually defeated the client and basically got her to withdraw her counterclaim that he'd caused any damage. Critical reputational takeaway, probably worth more than the financial money at stake. Now, I just want to conclude by saying that the real interesting area is, and this is something that people don't understand, is that, and this is the final thing that I advised the client to do at the hearing itself, was to produce a short schedule. In this case, it was just a printed off email of the costs that my client, the architect, had incurred as a result with dealing with this late filing of a counterclaim, all this additional documentation, and including the legal fees to me for having to take legal advice last minute, because he approached me a week before the hearing. And I charged him that £450 for the probably about 3 or 4 hours work that I did on his case. I tried to keep it proportionate, even though it wasn't sort of an exact hourly rate. I charged 150, so he got extra from me, if you like, which was fine. So I tried to keep my costs down in proportion to the amount of money which was at stake, which was only £2,500. Anyway, although there was more at stake when you think about the reputational side of things. Anyway, so here's the thing. He submitted his costs, Now, in these interlocutory hearings, go back to this point about this is not the trial. You're not there to prove to the judge that you're right and the defendant's wrong on, the merits of your claim. You're here to say to the judge how this counterclaim has been brought very late, in a very poor way. The defendant's been disorganised, and you don't think. And finally, but only the final point that you might make in passing is, we don't think the counterclaim has got any merit whatsoever, Your Honour, and this is probably why it's been brought so late. So do you see how you're fighting the procedural part of the litigation, and you're not fighting the substance of the claim itself? Now, you ask the judge to kick the counterclaim into touch and not to allow it to be admitted. You don't want to have to fight $5,500 counterclaim when you're just claiming for $2,500. But the judge will often say, if this had gone to trial and the parties hadn't settled, this would have been much more of an important issue. The judge is likely to say, well, I'm sorry, I accept the counterclaim may look weak, but it's got a sufficient threshold to take it to trial. The last thing our client wants a whole day in court when he could be running his one-man business. Now, here's the thing: but you make that point to the judge, of course, but then you say, okay, Your Honour, but fine. What about our costs? Now, a court is far more likely to side with you and make a costs award against your opponent. Yeah, and that is he'd be very tempting, and the other side would have, in this situation, would have had to battle quite hard to row back from that position. You know, we want our costs, the extra aggravation of this counterclaim being served incomplete and late. And you know what? You probably get them in a case like this. And why that's important is the defendant is now, look, you know, my cost $450, perhaps the architect claimed a bit of costs on top. Although even though it's a small claim, in a situation like this, the court has discretion to step aside from the small claim criteria, particularly if it's an earlier stage of proceedings. And he has discretion anyway where he believes that the defendant has behaved unreasonably to make a costs award, and he's more likely, I think, he would have been quite likely to make a costs award in this case. Now, obviously, that's important tactically because the defendant, who was not, you know, earning, it was clearly a little hard up, probably why she's wriggling out of the invoice in the first place, goes away and thinks very carefully about the whole claim when she's having to write a cheque for £500 or £1,000 because she's just lost an interlocutory hearing in the claim for £2,500. So there it is. Remember, when you may be faced with an unexpected application, mini hearing, they're called interlocutory hearings during the course of civil litigation, don't be swamping the court in evidence, don't be trying to convince the court of the merits of your claim. Be clever about, in a way, scoring procedural points over your opponent, okay, and perhaps getting a costs order against them that may well dissuade them against further litigation and proceeding with their claim, particularly, as was the case here. She actually ended up crying over coffee to my client and withdrawing her counterclaim, particularly as is the case here, where the counterclaim really was something of a ploy rather than something of any real substance. Okay, thank you for tuning in. I've got a couple of more issues to address relating to this particular case, because it was a fascinating case. Hard work for my architect client, but fascinating and interesting for us lawyers. So that's all for today. Good night.